Welcome back. Today we are breaking down a major shift in the legal landscape surrounding gun bans and why this moment could be so important. In this video, we are going to look at what is driving the momentum, why the courts are under growing pressure to act, how recent Second Amendment rulings continue to shape these fights, what this means for pending cases, and why Supreme Court involvement may now feel closer than ever. What makes this moment so important is that these legal fights are no longer isolated disputes happening in just one courtroom or one state. They are becoming part of a much broader national wave of challenges, and that is a major reason people say momentum is building. More lawsuits are now moving through the federal court system involving bans on certain types of firearms, magazine capacity restrictions, and other related regulations. When that happens, the issue becomes much harder for the judiciary to avoid or treat as a narrow local matter. As more cases are filed and more judges are required to rule on similar constitutional questions, the legal pressure begins to increase. Each decision adds to the larger conversation about what the Second Amendment protects and where governments can draw regulatory lines. That process matters because constitutional law often develops through repeated conflicts in multiple courts, rather than through one single case alone. When similar questions keep appearing again and again, the chances rise that higher courts will eventually have to provide a clearer and more uniform answer. Another reason this expansion matters is that it shows how seriously both sides are taking the issue. Challengers see an opportunity to test whether modern gun bans can survive under current constitutional standards, while governments are working to defend those laws as valid public safety measures. That means the legal conflict is becoming more active, more visible, and more nationally significant. In practical terms, momentum does not just mean that people are talking about these cases more. It means the actual machinery of the legal system is increasingly engaged. More filings, more hearings, more written opinions, and more appeals all signal that this is becoming a sustained legal battle rather than a temporary controversy. That is why this first point is so important. The growth of these cases across the country suggests that the fight over gun bans is entering a more serious and consequential stage, one that may shape future court decisions far beyond any single lawsuit. A major reason these gun ban cases have gained so much traction is that the Supreme Court changed the way lower courts are supposed to evaluate Second Amendment challenges. That shift did not just adjust a minor detail of legal analysis. It altered the entire framework that judges use when deciding whether a firearm restriction is constitutional. In earlier years, courts often relied on balancing tests that gave governments more flexibility to defend gun laws by arguing that the regulations served important public interests such as safety or crime prevention. Under that approach, many restrictions survived because judges gave substantial weight to those policy arguments. Now, the focus has moved much more heavily toward constitutional text, history, and tradition. That means courts are expected to ask whether a modern firearm regulation is consistent with the historical understanding of the right to keep and bear arms. This is a much different inquiry, and it has become central to nearly every major Second Amendment case moving through the courts today. For challengers, that change is significant because they believe many modern bans are now on weaker constitutional ground than they were under the old approach. This does not mean every challenged law automatically fails, but it does mean the government's job has become more demanding. Instead of simply arguing that a restriction is reasonable or beneficial, officials may have to show that comparable regulations fit within the nation's historical tradition of firearm regulation. That is where many of these cases become difficult and highly contested. The result is that lower courts are now wrestling with a more rigid and historically focused constitutional test, and that has energized litigation across the country. Lawyers, judges, advocacy groups, and state governments all understand that the stakes are higher because the rules of the legal game have changed. That is why this second point is so important. The momentum is not coming only from the number of cases. It is also coming from the fact that the Supreme Court's own framework has given those cases new force, new urgency, and much greater national significance. One of the biggest reasons these cases feel like they are gaining real momentum is because lower courts are not speaking with one clear voice. Different judges are reaching different conclusions about how to apply the Supreme Court's modern Second Amendment rulings, and that kind of disagreement is a major sign that the issue is becoming more serious at the national level. When courts interpret the same constitutional principles in different ways, it creates uncertainty, not only for lawmakers and litigants, but also for the public trying to understand what the law actually is. Some courts have taken a more skeptical view of firearm bans and related restrictions, concluding that certain laws may not fit comfortably within the constitutional framework the Supreme Court has laid out. Other courts have been more willing to uphold those same types of regulations, often reading the court's guidance more narrowly or giving governments more room to defend the laws. That split matters because it suggests the legal standard is still being contested in a very real way. The fight is no longer about whether there will be litigation. The fight is now about which interpretation will ultimately prevail. This kind of judicial division often places increasing pressure on the Supreme Court. The court is more likely to step in when lower courts begin drifting apart on important constitutional questions, especially when those questions affect fundamental rights and have consequences across multiple states. A patchwork of rulings can leave people in different parts of the country subject to very different legal realities, even though the Constitution is supposed to apply nationally. That is why disagreement in the lower courts is not just legal noise. It is one of the clearest signals that these gun ban battles are moving toward a point where broader guidance may be needed. As conflicting opinions continue to accumulate, the pressure builds for a more definitive answer. In that sense, the split itself becomes part of the momentum, pushing these cases closer to the kind of national importance that can draw direct Supreme Court attention. What makes these cases especially important is that the stakes extend far beyond any single law or single state. On the surface, a lawsuit may appear to focus only on one specific ban, one category of firearms, or one set of restrictions. But in reality, the legal reasoning used in these cases could influence many other parts of Second Amendment law. That is why so many observers view these battles as potentially transformative rather than isolated disputes. The outcome could shape how courts evaluate a wide range of firearm regulations for years to come. When a court issues a major ruling in one of these cases, it does more than resolve that immediate conflict. It can establish principles, interpretations, and legal standards that other courts may use when examining related restrictions. A decision about a gun ban today could affect future cases involving magazine limits, licensing systems, carry regulations, firearm classifications, or other rules that governments put in place. In constitutional litigation, one precedent often becomes the foundation for several later disputes, especially when the issue involves a broadly debated individual right. That is why both supporters and opponents of these laws are paying such close attention. They understand that these lawsuits may help define not just whether one policy survives, but how aggressively states can regulate firearms moving forward. If challengers win a strong ruling, it could open the door to new legal attacks on other restrictions. If governments win, it could reinforce the idea that certain categories of regulation remain permissible even under the Supreme Court's modern Second Amendment framework. In other words, these cases are acting like pressure points in a much larger constitutional struggle. They are testing the reach of the Second Amendment and the boundaries of government authority at the same time. That broader significance is exactly why the momentum matters so much. The decisions made here may not stop with one courtroom victory or one state law. They could influence the legal direction of firearm policy across the country and set the tone for the next generation of constitutional challenges. Another major reason people are watching these cases so closely is the growing sense that Supreme Court interest may be building. That does not mean the court has already decided how it will rule, or even that it has committed to hearing a particular challenge right away. But as more gun ban cases move through the lower courts, and as more judges issue opinions interpreting the Second Amendment in different ways, the pressure on the justices naturally increases. The Supreme Court often steps in when an issue becomes too significant, too inconsistent, or too nationally important to leave unresolved for long. That possibility is what gives this moment so much added weight. Court watchers understand that the justices do not need to take every case to shape the law. Sometimes the signal comes from the kinds of cases they allow to continue, the issues they repeatedly see returning to them, or the broader pattern of legal conflict developing below them. When multiple challenges begin raising similar constitutional questions, especially after a major Supreme Court precedent has already changed the legal framework, it becomes harder to ignore the need for clarification. There's also a practical reason this matters. If lower courts continue to disagree about how to evaluate gun bans, states may end up operating under very different legal rules depending on their jurisdiction. That kind of inconsistency can create exactly the sort of national confusion the Supreme Court is often asked to resolve. The justices may eventually feel that clearer guidance is necessary, not only for judges, but also for lawmakers, litigants, and the public. So the real point here is not that Supreme Court action is guaranteed tomorrow. It is that the legal conditions that often lead to Supreme Court involvement appear to be strengthening. More litigation, sharper disagreements, and higher constitutional stakes all contribute to that sense of rising interest. That is why this key point matters so much. The momentum is no longer just about what lower courts are doing. It is also about the growing possibility that the highest court in the country may soon be forced to weigh in more directly. One of the most important things to understand about this issue is that momentum is not the same as final victory. When people see strong headlines about gun ban cases gaining ground, it is easy to assume the legal fight is already settled or that one side has effectively won. But that is not how major constitutional litigation usually works. These cases often move slowly, develop over time, and pass through several stages before any truly final resolution is reached. A promising development can be significant without being the last word. That distinction matters because the legal system is built around process. A case may begin in a trial court, move to an appellate court, face delays, return for additional review, or even be affected by decisions in other related cases. Along the way, rulings can be narrowed, expanded, paused, or reversed. So when we talk about momentum, what we really mean is that the issue is advancing, gaining visibility, and forcing courts to engage with it more seriously. It does not mean every challenge will succeed or that a sweeping nationwide outcome is immediately around the corner. At the same time, momentum should not be dismissed as meaningless. In high-profile constitutional disputes, momentum can shape public attention, legal strategy, and judicial urgency. It can encourage more challenges to be filed, lead advocacy groups to invest more heavily in certain arguments, and increase the pressure on appellate courts to provide clearer answers. It can also signal that an issue is entering a more consequential stage, where the decisions being made start carrying broader national implications. So the key takeaway is balance. This is not the moment to declare the battle over, but it is absolutely a moment to recognize that the battle is intensifying. The legal ground is shifting. The arguments are becoming more focused, and the courts are being drawn more deeply into the conflict. That is why momentum matters so much here. It marks the transition from scattered disputes to a more serious and potentially historic phase of constitutional litigation.